This is AM 650's The Law Show with Sterling Fox. Now back to the show.
Good to have you with us this Sunday morning. Our guests, David Hobbs and Ian Giroday from Hobbs Giroday, Vancouver estate litigation lawyers with offices downtown opposite the courthouse. They are online at hobbsgiroday.com. Talking about, well, we've been talking for most of the program, Ian Giroday, about the successful methods of estate planning to avoid, well, taxes, among other things, and disputes and challenges to wills after you have passed on. And that's, of course, what you do. You represent people who are challenging the terms and conditions of wills. So let's talk about that person who comes to Hobbs Giroday, and they're stunned they've received so little. All of the dispositions have taken place, all the taxes have been paid, and now there's the rest of the estate. And for whatever reason, and there doesn't appear to be anything defined, I'm just hooped. I'm just out of the game. I get almost nothing. So how do you get back into the game with that person?
Right. So a person who is upset about the contents of a will, who comes to see us, usually often they may not appreciate that there's very little in the estate to be distributed.
Okay.
That the will maker has arranged his or her affairs so that most of their property passes outside of the estate.
As in gifts and trusts that we've talked about.
So the first thing we're doing with a person who comes in and says, I was only left, I was left nothing under the will, or I was left a pocket watch from
Sure.
dad, and all my other siblings share equally in the residue, and that's where most of the assets are. We would be asking questions and conducting some investigations, perhaps, to determine what's in the estate. One of the things we might do is we might wander across the street to the probate registry and pull the probate file and see what's on the disclosure statement.
And that's right there. And you mentioned earlier, David, every estate has to file one of these description of financial circumstances, right?
Right.
So you can just do that.
Right. A member of the public or a lawyer can go over to the probate registry and say, I'd like to see this probate file, please. There's a small fee,
Right.
unless you're on record.
But then you immediately know how much money is at play.
Right. And because there's no obligation to give every person named in the will or the children the statement of assets and liabilities.
Right.
They may have it, they may not. So we're doing a little bit of investigating, and we might be giving some bad news to this person who comes in to see us, and that is, it sounds like you have a pretty good wills variation claim based on what you've told us in terms of the how the will was or how the will directs that the gifts be distributed and so forth. But the problem is there's nothing in this estate, or very little in this estate, to vary, because the life insurance and the RRSP and the house, the family home, the bank accounts, they've all been buttoned down outside of the will. They've all been transferred outside of the will.
Basically, this person has followed all of the tips and strategies that we've talked about for the past hour. There's really nothing left.
Right. So now the shoe's on the other foot for us. We're looking at, rather than how does one estate plan to avoid wills variation, we're looking at, what tools and law is available for us to challenge all of these transfers that occurred outside the will.
Right.
Some or all of these transfers. So we're looking at things like, was the transfer of the home, as we discussed earlier, really only a transfer of the legal title and the beneficial title, or the sale proceeds? There's some sort of trust relating to that. Was the transfer of the bank accounts really meant to be a gift to the joint account holder? Or was that joint account set up for some other reason? Were they the power of attorney, and were they using the funds solely for the care and assistance, paying the bills of the deceased? There's a host of things that we'll be looking at. Did the will maker have the capacity to transfer the home into joint tenancy at the time that they did? So therefore challenging the validity of that transfer.
So basically, if a person is involved in a will and an estate and the disposition of the assets, and feels shortchanged for one reason or another, and there may be multiple reasons, there may just be one reason, that person should seek out a lawyer, get some professional advice, and find out at least where they stand and what efforts they can make to get involved, correct?
Well,
see a lawyer.
It's complicated stuff.
Right, so see a lawyer and get it sorted out.
Right, things may not be as they appear.
Right.
And it's some of it involves some complex concepts of law that the person on the street might not appreciate.
All right. Hobbs Giroday is the place to go for Vancouver estate litigation issues. They're easily found online at hobbsgiroday.com. They're right downtown, right across from the courthouse on Howe Street, and they'll take care of you. David Hobbs and Ian Giroday, thanks for being with us on this December 1st. Merry Christmas to you both. And we'll see you not quite next year, but our New Year's show coming up at the end of the month. Take care.
Merry Christmas, Sterling.
Thanks, Sterling.